Hello, my name is Danielle Matthew. I'm an assistant professor at the National Law University, Delhi. Today we would be continuing our lectures on human rights, especially we are looking at the national human rights mechanisms. And today's module will then cover implementation of human rights through national institutions. There are a broad spectrum of mechanisms at the national and the state level in India. Primarily, it's headed by the National Human Rights Commission. It has its sister organizations in the state as the State Human Rights Commission. We have the National Commission for Scheduled Caste, Scheduled Tribes and Backward Classes. We have the National Commission for Women, the National Commission for the Protection of Child Rights, Commission for Minorities and Commission for Safai Karamcharis. The National Commission for Scheduled Caste and the National Commission for Scheduled Tribes is established under the Constitution of India, Article 338 and 338 respectively, which was inserted into the Constitution through the 89th Amendment Act of 2003. The rest are statutory bodies, namely the Protection of Human Rights Act 1993, the National Commission for Women's Act 1990, the National Commission for Backward Classes Act 1993, the National Commission for Minorities Act 1992, the National Commission for Minorities Procedures and Process Regulations 1997, and finally, the Commission for Protection of Child Rights Act 2005. Today's topic of discussion, which is essentially the National Human Rights Commission, was established on October 12, 1993 under the Protection of Human Rights Act 1993. The act establishing the National Human Rights Commission is claimed to be in tune with the Paris Principles 1991, which was adopted by the United Nations General Assembly via its Resolution 48 of 134 dated December 20, 1993. Paris Principles, as it's widely known, concerns the status and functioning of the national institutions for protection and promotion of human rights and includes comprehensive recommendations on the role, composition, status and functions of the national human rights institution. In India, importance is given at an enormous level for both the human rights and fundamental freedoms which are guaranteed in the Constitution. The same casts duties on the state, ensuring that the state and other private parties do not encroach upon these basic rights, and an attempt is also made to ensure conditions exist so that individuals can develop capacities to fully exercise these rights. The overarching purpose for NHRC, therefore, is protection, preservation, and promotion of human rights. In broad spectrum, NHRC is the guardian of these rights and ensures that it is able to discharge this function. It performs an array of functions. At this juncture, we will simply list them out and return to them later in greater detail. These functions include inquiry, function of intervention, ability to review, ability to undertake studies and research, dissemination of human rights literacy, and finally encouraging human rights civil society organizations to participate in protecting human rights. More specifically, NHRC evaluates existing safeguards for human rights protection and makes recommendation for strengthening them, inquires into complaints of human rights violations, at the same time undertakes visits to custodial and other institutions, creating an awareness about these rights, and finally, promoting harmonization of domestic laws with international conventions and undertaking research and analysis on human rights issues. NHRC is an autonomous body. It is understandable why that should be so. NHRC is meant to audit states' functioning. It is meant to see that state protects and promotes human rights. If it is dependent on the state, it would hardly be able to discharge this function. Therefore, to ensure that NHRC works in an independent manner, NHRC has been designed to be an autonomous body. It's a creature of statute, and its members, chairperson including, are selected in a manner so as to ensure neutrality from the state. The appointment process, both for the chairperson and members, is done by a committee which recommends to the president to make the appointment. Members of the committee are the Prime Minister as its chairperson, the Speaker of the Lok Sabha as a member, Deputy Chairman of Rajya Sabha, Minister of Home Affairs, Government of India, Leader of the Opposition both in Lok Sabha and Rajya Sabha acting as members. The chairperson of the National Human Rights Commission is the Chief Justice of India, a former Chief Justice of India. And its other members are a judge who is currently serving or a retired Supreme Court judge, a currently serving or retired High Court, Chief Justice of a High Court, 2 members who are appointed from civil society who have extensive knowledge or practical experience in matters relating to human rights, and finally, the chairpersons of the National Commission for Minorities, National Commission for Scheduled Caste, National Commission for Scheduled Tribe, and National Commission for Women serve as ex officio members on the Commission. Its working structure also includes an officer of the rank of Secretary to the Government of India. This officer, acts as the Chief Executive Officer for the Commission. In addition to him, there are special rapporteurs, individuals who are experts and are asked to provide their expertise on a range of subjects which may be, say, bonded labor, child labor, custodial death, disabilities. They could also have territorial jurisdiction into or over certain specific territories within India. These special rapporteurs, as experience suggests, are senior officers who, prior to their retirement, have either served as secretaries to the Government of India in various capacities or have been Director General of Police and have had an exemplary service in human rights related field. In addition to these special rapporteurs, there also exist certain core groups, expert groups, and special investigation teams. They consist of very eminent persons who are essentially representatives from the civil society and who are experts in the field of human rights, who voluntarily agree to serve on these groups in an honorary capacity as members. Presently, there are 11 such groups, including Core Advisory Group on Health, Core Advisory Group on Disabilities, Expert Group on Unsafe Drugs and Medical Devices, Core Advisory Group on Bonded Labor, Core Group on Legal Issues, Core Group on Right to Food, an Expert Group on Refugees, Core Group on Protection and Welfare of Elderly Persons. Their reports can be found on the website of the National Human Rights Commission. Notable reports of these groups have included improvement of forensic science laboratories, which was submitted in 1999, and recommendation of the Core Group on Health relating to organ transplantation, which was submitted in 2004. The working structure of National Human Rights Commission also includes 6 divisions. These would include the administrative divisions, which looks after the staff matter. For our purposes, what's more important is the legal division, which manages the receipt and disposal of complaints concerning human rights violations which are received from across the country. The investigation divisions, which conducts independent investigation and inquiries and assist the Commission in examining complaints, scrutinizing reports which are received from police and other investigation agencies, and looks into reports of custodial violence and other misdemeanors affecting human rights. They also analyze intimation and reports received from state authorities regarding deaths in police and judicial custody, encounter deaths, and advises the Commission on further course of action. The investigative division also draws on its experience to assist the training division, which works towards dissemination of information and focuses on sensitizing various agencies, NGOs, and civil society organizations to heighten the respect for human rights by creating a culture of human rights and by organizing various training programs across the country. Finally, we have the Information and Public Relations Division and the Policy Research Program and Project Division, which the Information and Public Relations Division working towards sensitizing, providing information on workings of NHRC and providing greater information on rights of people. The Policy Research Program and Project Division, as the name suggests, undertakes extensive work and projects concerning protection and promotion of human rights across country. Today's discussion primarily works on the functions of National Human Rights Commission. The Commission has a wide mandate to protect and promote civil, political, social, economic, culture, and group rights. Section 12 of the Protection of Human Rights Act 1993 namely lists down the following functions. 1. The function to inquire. The National Human Rights Commission, either suo motu or on petitions presented to it by victims or any person on behalf of the victims, what we usually call best friends, or on direction or order of any court, look into complaints of violation of human rights or abetment thereof, or negligence in prevention of such violation by a public servant. The idea is to ensure that correct information regarding what has happened on ground vis-a-vis a violation of human rights is obtained. The Commission also intervenes or carries the ability to intervene in any proceedings involving any allegation or violation of human rights which is pending before a court. However, such can only be done with the approval of the court. The National Human Rights Commission also carries the ability and has the mandate to visit, notwithstanding anything contained in any other law for the time being in force, any jail or institution which is under the control of the central or the state government, where persons are detained or lodged for the purposes of ensuring that they are treated humanely. These persons may be lodged for protection, for reformation, or for treatment. The idea is to ensure that human dignity is protected, that their living conditions adhere to minimum requirements as noted in various decisions of the Apex Court, and make recommendations if they are to come to a conclusion that the living requirements do not meet the minimum required standards. They are also mandated to review the safeguards which are provided by or under the Constitution or any other law for the time being in force to ensure protection of human rights and make any recommendations for the implementation of these safeguards. Incidentally, the National Human Rights Commission is also required to ensure that there is a culture or there are in place necessary provisions or necessary possibilities to enjoy human rights. Therefore, it has the ability to review factors that inhibit the enjoyment of human rights and recommend appropriate remedial measures. National Human Rights Committee, under its wide mandate, is also required to study treaties and other international instruments on human rights and make necessary recommendations to ensure the Indian law is in line with the obligations undertaken by the State of India under these international conventions. National Human Rights Commission is also required to undertake and promote research in the field of human rights. In order to aid in discharge of this mandate, the National Human Rights Commission on a very regular basis engages with academic institutions. For instance, the National Human Rights Commission is also required to engage in sensitization and therefore spreading of human rights literacy amongst various sections of the society. To do this, it is also mandated to encourage and work closely with non-governmental organizations, civil society organizations working in the field of human rights. In addition to this wide mandate, it has been given a residuary power also to undertake any function that it may consider necessary for the promotion of human rights. The National Human Rights Commission, to discharge all functions as noted earlier, has been given wide powers. In particular to note is the power that it carries for those such as which are akin to the powers of a civil court trying a suit under the Code of Civil Procedure 1908. This power, among other things, also includes the power to summon and enforce attendance of a witness and examine them on oath, discovery and production of any documents which may be under the control of any central or state official, receive evidence on oath from any entity including officers or normal citizen, requisitioning public documents, issuing commissions for examination of witnesses and documents. Additionally, it also has the power to grant interim relief and has the authority to recommend payment of compensation or damages. Under its wide mandate and over the last 2 decades, National Human Rights Commission has achieved enormous goals. Few of its relevant work are reviewing of laws and bills and international instruments on human rights. It has worked intensively in areas of insurgency and terrorism to ensure protection of those who are caught with the apparatus of the state. It has worked towards issuing of guidelines to check misuse of the powers of arrest by police. It has also been successful in setting up of human rights cell in certain police headquarters. There has been efforts which have been taken owing to the efforts of NHRC to ensure reduction in custodial death, rape and torture. If you would recall that this perhaps has been the worst, or India has a worst track record insofar as death in custody or violation of rights of women when in custody. It is at the behest of efforts of NHRC that directions were issued by the Supreme Court, and the result is there to see. The National Human Rights Commission also has ensured and worked towards reform of police and working of detention centers. In addition to it, it has worked to ensure humane conditions in jails, for inmates in jails, mental hospitals, and similar other institutions. As we would progress, we would see a few case studies to this effect. National human rights have been working tirelessly to ensure the rights of vulnerable groups are protected. For instance, human rights of those persons who have AIDS or carry the HIV virus, or people who are displaced by large-scale projects. A case in point would be the people who were displaced owing to the construction of Narmada Dam. NHRC and its members were on ground to ensure or take stock of the measures which were taken by the state to rehabilitate people who were displaced. They made concrete suggestions, which suggestions were finally taken on board by the Supreme Court in a case which was initiated by the Narmada Bachao Andolan before it. National Human Rights Commission also has worked tirelessly to put food security and health as a major human rights issue in India. The decisions of the Apex Court noting contribution of NHRC in decisions concerning right to food and right to health as a fundamental right are to be duly noted. In addition, NHRC has been at the forefront of initiating discussions on refugee law in India. As you would know, India has no statutory law at the moment on refugees. There has been a lot of pressure on India to sign the Convention on the Status of Refugee, which India has been steadfastly refusing for various reasons, whether legal or political. National Human Rights Commission has been working tirelessly to ensure at least a platform is created where discussions relating to accession to CSR could be done. National Human Rights Commission was instrumental in initiating a debate on whether non-citizens would have fundamental rights. In this idea, or in this instance, the work done by National Human Rights for the Chakma refugees is perhaps a case in point. National Human Rights Commission interfaced with the Supreme Court to ensure protection of the Chakma refugees in a very popular and perhaps well-known case of the National Human Rights Commission of India versus Arunachal Pradesh, 1996. The PowerPoint presentation would give you the exact citation. The brief facts of this case perhaps could be traced back to the partition of India. At the time of partition, there was a lot of movement of Chakma refugees from across the border from East Pakistan, as it was then, and Bangladesh now, into India, especially around the northeast states. During partition, since it was the division of the country, it was accepted, and over time an influx of refugee status ensured that there was a substantial population of Chakma or Hajong tribals in the northeast states of India. In addition to this, sectarian violence right after partition also prompted or further fueled the immigration from East Pakistan into India. As the time went by, power projects such as the Kaptai Hydel Power Project, which was undertaken by Bangladesh, led to enormous displacement and saw further movement of the Hajong tribals into India. As a temporary measure at that point of time, the state of India settled the Chakma and the Hajong tribals in the northeast states, especially in the state of Arunachal Pradesh. Since the number was small, it was considered to be a non-problem. However, over the years, the tribals have stayed, and questions have arisen time and again as to what their status is. Additionally, Arunachal Pradesh is a state which predominantly has a lot of scheduled tribes. The Chakma tribals have been seeking the status of scheduled tribes, which has put a lot of tension on the social fabric of the state. The resulting situation has been pretty volatile when one compares or looks at it from a political point of view. Each year, every time the elections turn up, the political parties to further rake up this matter, and there has been for a very long time no solution in sight. The situation was such that quit Arunachal Pradesh or quit Assam notices were issued to Chakma refugees, and when that did not happen, violence was perpetrated on them. This situation was brought to the notice of National Human Rights Commission, which in turn brought it to the notice of the Supreme Court. The Supreme Court in this matter propounded an important understanding of the fundamental rights in India. The Supreme Court said that fundamental rights, except Article 19, is available not only to citizens of India but also to non-citizens. Thus, the significance of the judgment is about the applicability of fundamental rights to refugees. The decision rules that foreigners are entitled to enjoy the protection of right to life and personal liberty under Article 21 of the Constitution. The court further directed the state of Arunachal Pradesh to ensure that the life and liberty of each and every Chakma refugee residing in the state is protected. National Human Rights Commission, as the nodal agency, has been ensuring that this direction of the Supreme Court has been adhered to. Over the years, one has seen remarkable improvement in the condition of Chakma refugees, especially in their fight to obtain citizenship. In the last elections, or elections previous to that, some of the Chakma refugees were able to get their names onto the electoral list. This marks an immense departure from the previous stand which has been taken by the state of Arunachal Pradesh and state of India overall to ensure rehabilitation and assimilation of Chakma and Hajong tribals into the Indian fabric. This was done at the behest and efforts of the National Human Rights Commission. National Human Rights Commission has also interfaced with the Supreme Court on the issue of bonded labor. As you would realize, India has the largest market for human slaves. They are mostly found in brick kilns. Numerous work or efforts of central government and various state government to eradicate bonded labor has failed. This is indeed a sad sight or sad situation considering 60 years have passed after the promulgation of the Constitution of India. The Commission was involved in monitoring of the implementation of the Bonded Labour Systems Abolition Act as per the direction of the Supreme Court in PUCL versus the state of Tamil Nadu and others. It was a case which started in 1985 but directions were issued after 1993. The Commission monitors the Bonded Labour System Abolition Act by calling on information from various states. The idea is that continuous evaluation from states keeps them on their toes, ensures that the state takes adequate measures through programs and involving the civil society organizations to ensure an eradication of bonded labor. These reports have to be submitted to the National Human Rights Commission on a quarterly basis, and the aim of this report is identification, release and rehabilitation of bonded labor, which means each state has to ensure that it on a periodic level puts out programs for releasing, for identifying and ensuring release of bonded labor. Not only that, they have to make efforts to ensure that those who are released do not go back to the system owing to lack of opportunities. Thus, a comprehensive program on rehabilitation has to be ensured by each and every state. National Human Rights Commission, under directions from the Honorable Supreme Court given in PUCL versus state of Tamil Nadu, helps the state in coming up with comprehensive programs. In September 2000, the National Human Rights Commission constituted a group of experts to examine the matter of bonded labor and to prepare a report on the status of bonded labor in various states in India, suggest method for improving the existing schemes in different parts of the country, and make recommendations to effectively implement the law for abolition of bonded labor and other connected matters. The National Human Rights Commission, perhaps the most famous case with which it was involved, was the functioning of mental hospitals at Ranchi, Agra and Gwalior. The management of the mental hospitals at Ranchi, Agra and Gwalior came under scrutiny of the Supreme Court in a writ petition titled Rakesh Chandra Narayan vs. State of Bihar, which was first filed in 93, 94 and later 96. The issue was that inmates of these institutions were treated very badly. In many instances, there were issues of abuse, including torture. The Supreme Court took up the matter and directed the National Human Rights Commissions to look into it and submit a report. The National Human Rights Commission appointed a member and a special rapporteur to visit these institutions and take stock. It concluded that reports of ill treatment, torture were true and reported the same to the Supreme Court. Under directions from the Supreme Court, a member and special rapporteur of the Commission are to visit and indeed do visit these institutions periodically, almost on a quarterly basis, and submit detailed reports on the working of various services and facilities available to the inmates, the kind and treatment and care given to the patients, the kind of training and research activities which are undertaken, and the health services which were specified by the Supreme Court is provided. Efforts are also made by NHRC to train the personnel of these institutions so that they can ensure that their treatment towards the inmates are in compliance with basic rights and fundamental freedoms of all individuals. Finally, the NHRC was also involved with the functioning of the Government Protective Home for Women in Agra. This case came into prominence by the efforts of a prominent academic in India, Professor Dr. Upendra Bakshi, and the case was called as Professor Upendra Bakshi versus State of Uttar Pradesh. Professor Bakshi brought it to the notice of the Supreme Court that women in the Government Protective Home, especially in Agra, were in perhaps the most pitiable situation. There were instances of abuse, including sexual abuse, and despite bringing the matter to the notice of the government of Uttar Pradesh, nothing much was being done. The Supreme Court took stock of the matter and asked the National Human Rights Commission to intervene and produce a report. The National Human Rights Commission investigated the matter and concluded that whatever which was alleged by Professor Bakshi was indeed true. Based on the recommendations of NHRC, the Supreme Court directed the NHRC to take periodic stock of how these institutions were run. Accordingly, a member of the Commission, including a special rapporteur, frequently visit the home to make a broad assessment of the functioning of these institutions. These are just a few examples of the interventions which were made by the National Human Rights Commission. Similarly, under similar directions given by the Supreme Court in multiple cases, the National Human Rights Commission has taken stock of working of government institutions and wherever necessary issued recommendations and directions to ensure that the basic human rights and fundamental freedoms of the inmates are protected under all situations. In addition to this, National Human Rights Commission also undertakes extensive reporting. It prepares the Universal Periodic Review which is submitted to the Human Rights Council. Essentially, it produces what is called the country report. This country report is taken by the Human Rights Council, discussed and debated, and the state of India has to ensure that it is able and in a position to respond to whatever that is noted in the particular report. Now, NHRC has been doing a commendable job in terms of putting out an honest, straightforward report on the human rights situation in India. In addition to this, NHRC also produces the country report on the implementation on the elimination of discrimination against women, CEDAW, in CEDAW. The idea is to ensure that attempt is always made to reduce gender-based violence and gender-based discrimination. NHRC's efforts have been commendable in that field. So broadly, that was the working of NHRC. However, we cannot part with this particular topic without giving some critical thought on the functioning of NHRC. From our past experience, there are certain areas of concern, primarily accessibility, effectiveness, following up of recommendations of the Commission, independence of the Commission, and adequacy of the resources. We will take each one of these in turn. Accessibility. The idea is that NHRC should be accessible to all, anyone whose rights are or have been violated. The problem that arises is NHRC as an institution is based in Delhi. Human rights violations that happen across the country. Though NHRC has attempted to reach out through its special rapporteurs and core groups, unfortunately, the breadth of the country is so vast that it is next to impossible to cover all. NHRC, though it could have its wings in different parts of the country, has failed to do so, leading to a situation where accessibility itself becomes a question. Effectiveness. One of the biggest problems that NHRC has is ensuring implementation of its directions. At times, there have been situations where directions have been issued to the central, state, or other machineries of the state, and they have been disregarded. This leads at some point of time to a conclusion that NHRC may be a paper tiger. Things are not that bad. However, there are situations where recommendation of NHRC has been blatantly disregarded, and the only option left with NHRC then is to approach the Supreme Court. That is a tedious process, and unless something is done, this diminishes the effectiveness of NHRC. Independence of the Commission. Much has been done to ensure that the Commission is independent through the appointment of judges, sitting or ex-judges. However, there have been instances where the central government has avoided appointing a particular judge or member on the pretext that such member is not in line with what the central government thinks. This sort of a situation should not arise. In the event such situation does arise, leads to questions being raised on the independence of the working of the Commission. And finally, the adequacy of resources. Though the Commission may be independent, though the Commission may be effective in its working, unless and until adequate resources are made available to the Commission cannot work. Considering it is the only body which on a broad spectrum looks at violation of human rights, it must necessarily be provided with adequate resources, especially staff, to ensure it is able to reach out to every instance of violation of human rights. Today we looked at implementation of human rights through National Human Rights Institution. Our study was on National Human Rights Commission. We broadly looked at the Commission's setup, the working, the status and the function. The idea was to see whether or not only the talk of human rights exists, or also is there an effort to ensure that human rights are implemented at the ground level. So, institutions like the National Human Rights Commission ensures that human rights reaches to the lowest of the social ladder. However, there still remains problem in its working. An attempt should be made to ensure that these problems area are over time smoothened out. We hope you have learned much from this particular presentations. Enough information is available on the PPTs. More information is available on National Human Rights Commission's website. Thank you.